Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. Are you one of those people who's under the assumption that assets get split 50-50 on divorce? It's a belief that sounds neat, fair, and easy to understand. And that's probably why it's so persistent. And really, I hear it from a lot of people. The reality about divorce financial settlements is that it's not quite that straightforward. So, in this episode, which is part of our Debunking Divorce Myths with Gilson Gray series, we're going to unpack this assumption and compare it with what actually happens in practice. We're going to discuss why the 50-50 idea is so dominant and why people have this idea in mind, and actually what the law in England and Wales says, how the courts define fair, and how it's not always the same as equal. So, we're going to talk about all the different factors that come into play in deciding how assets get divided on divorce. We're also going to look at what a matrimonial asset is and what it isn't, and that's really important in defining how we split them later on. So to talk about this, I've invited Linda Pope. Linda is a partner in the family law team at Gilson Gray, and she's a specialist advising clients in divorce, separation, and private law children matters. Based in the London office, she has extensive experience of handling high-value financial claims with international multi-jurisdictional issues, family businesses, and trusts, as well as representing clients with limited assets where a novel solution is required. Linda, thank you so much for joining me today.
Chloe, thank you for inviting me to talk about this very interesting topic.
Yes, and such a common idea that is out there. And I think it's because it is the starting point, but we're going to talk about that in a minute. What do you
Yes.
think is the origin behind this idea that people have that it's literally just a formula, everything gets split in two?
It's probably to do with the Matrimonial Causes Act, 1973, so 23 years ago that this piece of legislation came into being. And that sets out how marriages and civil partnerships are dissolved, and also how the financial assets from that relationship are dealt with. And
Yeah,
the starting point is 50-50. So I think some couples get fixated on saying it's 50-50
yeah,
when that's the starting point. But the reality is, in limited circumstances, will it be 50-50? Because there's so many factors that the court have to take into account and the parties have to take into
yeah.
account.
And that's where equality doesn't always mean fairness, right? People think that cutting things in half, that is as fair as it gets, but actually it isn't because people's situations are different.
Yeah, again, if I had a pound for every time that somebody says, well, oh, they just get half of this and half of that, and that's fair.
Yeah,
Well, no, that's not fair. It's usually not fair to someone who is the economically weaker party to say, well, we'll split the net proceeds of the house 50-50, when because of their higher income, they have a higher mortgage raising capacity and
yeah,
they're able to buy a property. But somebody who is the weaker economic party in the relationship, who may be working part-time, or they've not worked at all in the relationship, they've not worked outside of the home, I should say, in the
yes,
relationship, they have a very small or non-existent mortgage raising capacity. So then if they get 50% of whatever, that equity is, they will probably struggle to
yeah,
rehouse.
yeah,
Um, Also, fairness doesn't always equate where one party is the primary caregiver of
yes,
children. So I know that, a lot of parents try to move to a shared care or joint living arrangement. Whether that works in reality all the time, no, because there is always going to be one parent that probably does have the children more time, especially if you've got one
mm,
party who probably has a demanding job or they work
mhm,
overseas and things, and then one party who probably has their career or job is around the children. And
yeah,
so even though the court tries to split, say, the equity in the home 50-50, so the children have a nice home with both parents.
Yeah.
If their primary home is with one particular parent, and that person happens to earn less, then of course it's fair for
Yeah.
them to have a bit more. And then the other thing I tend to hear a lot is with regard to pension splitting.
Yeah.
And this is where sort of third party experts come involved. They just say, oh, well, she or he gets 50% of my pension. Well, just
Yeah.
splitting it down the middle, yeah, they get 50% of the pension, but they get equality of income? So again, that's not necessarily fair. And again, you hear lots of one party will say, well, that's not fair. Why should they get more than half? Because
Yeah.
it's about equalizing what they will get. And if that means they get more than half of the pension pot, because you're going to continue probably adding to that pension
That's
pot,
exactly right.
they're not. So that's why
Yeah.
it's fair that at the outset they get a bit more,
Hmm.
because you're going to be able to build up that what you've lost in that pension. So those are kind of like the main things. And it's about ensuring that the parties after the marriage has been dissolved are roughly on the same footing.
Yes.
Not exactly the same. It might be, one has a little bit more, but roughly on the same footing.
Yeah. So these criteria, these additional considerations you've just mentioned, they are all part of what's called Section 25, right, of the Matrimonial Act. And then could you explain what is the method that judges use? Is it very discretionary in that they will just assess various needs based on these criteria, or is there more of a formula approach?
I would say that the thing is with family work is kind of it's difficult to say to a client, well, this will definitely happen in your case,
Yeah.
or this will definitely not happen, because the judges work within the law, the
Hmm.
statute, case law, but they do still have a wide discretion.
Yeah.
So what may happen for Mr. and Mrs. A on one day in one court, a
Hmm.
judge in a different court might come to a different
That's the
decision for
risk.
Mr. and Mrs. B, because they have that wide discretion. And it's
Yeah.
not because it's wrong.
Yeah.
Sometimes it is, but most times it's not because it's wrong. It's because they have that wide discretion. So, for example, most judges try, if they can, to achieve a clean break between the
Yes.
parties. So it means that, once they get their capital lump sums, one party does not have to pay ongoing financial payments to the other. So
Yeah.
in a situation maybe where one person was the primary caregiver or on a very low income, and somebody else was the higher wage earner in the relationship, there may be an argument that the higher wage earner pays the weaker economic person in the relationship
Yeah.
maintenance for a while until they get back on their feet.
Hmm.
Now, you may think, well, okay, well, because that happened in my neighbour's divorce,
Yeah.
that will be the same for me. But you don't know the ins and out of your neighbour's divorce. It could be that, she got a bit more of the capital, maybe a bit more pension, and that's the reason why they don't have to pay maintenance. In
Yeah.
your case, it may be there's not as much capital. I mean, by capital, I mean like cash, net
Yeah.
proceeds of the home, pension, to offset potentially paying an income. So there's
Yeah.
always different variables that a court looks at when deciding what should be at the outcome, and whether this should be a 50-50 split, clean break,
Yeah.
all of those things. So there is a bit of formula, but I would say that also it is in terms of the wide discretion that judges have.
Yeah. So it's not an exact science, and I
No,
think that's
it's
often
it's
hard
not.
for people to understand.
Yeah, and that's the difficulty in that with clients, we have to say to them, there is a wide discretion, and what we think might happen may not happen on
Yeah.
the day.
Yeah. And
Yeah.
I guess that's the roll of the dice of going to court with those kind of
Yes.
decisions.
Yes. Very much so.
And so I think, I guess one way of explaining it is the starting point is 50-50, and then it gets readjusted based on various factors like the duration of the marriage, where the children are living, earning capacity, things like that. And one of the questions I get asked a lot is, how far can it vary from 50-50? Could it be 80-20, or does it have to remain in that zone of 50-50?
Again, it kind of depends on the circumstances of the parties.
Hmm.
So, a case that I did a few years ago, there was a significant departure from equality. I think it was about 77% to my client and about 23% to the husband.
Yeah.
And the reason I think the judge came to that decision is there was some misconduct issues in the
Okay.
case, but that's not a sorry, that's not a major factor.
Hmm.
It was definitely based on needs. My client was the primary carer of
Yeah.
their child, minor child, and husband had a business,
Hmm.
and he was earning significantly more.
Yeah.
I would say probably the deciding factor in that case was husband was going to be spending a lengthy amount of time at His Majesty's pleasure. So even though at some point he would require some money when he's released,
Yeah.
um, the court took the view that, he wouldn't the wife had the immediate need. His
Yeah.
need would be 10, 15 years down the line. And so she needed the cash now to rehouse
That's
with
interesting.
self and the children. I had another case where there was a significant departure from equality, again in my client's favor. This was, I suppose, what you would call a May to December type relationship,
Yes.
in that my client was married to a much younger person.
Yeah.
It had been a relatively short marriage where she had not brought anything into
Hmm.
the marriage, any assets, and
Yeah.
essentially the matrimonial assets was what he had brought into the relationship. He was
Hmm.
retired, not in the best of health. She was a young woman in good health. She was able to work, but he wasn't able to
Yeah.
work because of his age and health. And the court was persuaded that it was appropriate in that case for there to be a significant departure from 50-50, given the contributions, duration of the marriage, the age of the parties. Um, so that was a reason.
Yeah.
And then another case that I did not so long ago, the court looked at the loss benefits because of the end of the marriage. And this happens a lot, that you will have a couple who've been married for a long time, and where, say, it's the wife who has been the primary caregiver, homemaker, her job was around, may have worked part-time, but essentially it's around
Yeah.
the children and the home. And they have this agreement that she wouldn't bother paying into a pension and he would.
Yes.
And so that's another reason where sometimes there is a departure from equality, certainly on pension, because the
Hmm.
judge will look at, okay, well, this woman may be in her mid 50s or early 50s, but what's going to happen in 10 years' time
Yeah.
when all she will have to is rely on the state pension? And we know, that's not something you can live on, and
Yeah.
that she is going to be possibly in a destitute position at
Yeah.
age, at her normal retirement age. And I think the other factor is that she wouldn't have the time to build up. a pension compared to
Yeah.
the husband's. So again, sometimes that's a reason why there is a departure from
Yeah.
equality because of the lost benefits she would have received had the marriage continued.
Yes. And I think that's back to what we were saying earlier around how you define fairness, and
Yeah,
it's not
yeah,
always equality. So the judges are looking effectively to make sure that as much as possible with what is in the matrimonial pot, both parties are ending up in a similar situation, at least in the immediate aftermath of the divorce. Is that is
yeah.
that
And
is
there's
that right? Is that what
voices
they're
saying, yes, no, there is. I mean, a judge, it's a bit like when you have one pot, how do you split it to ensure that both parties have a similar outcome? They're both
yeah,
able to live. And sometimes it may not be fair that maybe somebody, where they had, a big house and they had this wonderful lifestyle that, they may have to now go down to a one bedroom or two bedroom
yeah,
property so that they both have somewhere to live,
yeah,
so that they both have income to live in, pay day-to-day bills, and also looking forward to their retirement,
yeah,
that they will have money to live on. They won't be destitute as
absolutely.
pensioners. And so, although it may not seem fair or to the ordinary person in the street, there is
Yeah,
always like a reason behind
yeah,
that, and looking at, what does the parties need now and what will they need going forward in the
yeah.
future.
And how much do the courts consider past lifestyle and living standards in determining what's fair?
That's a really interesting one, because I remember again a case that I did many years ago, and the judge made a comment, and this has stuck with me, is
Yeah,
that they are obliged to ensure the parties are rehoused, but not
yeah,
necessarily in their own home.
yes.
So it's about having a housing fund that,
Hmm.
if that means you've got to rent, you've got
Yeah,
to rent. And if it means that you then have to go from your four-bedroom semi-detached house maybe to a two-bedroom flat, which is probably not in the best part of town,
yeah,
the judge has discharged their duty by ensuring that you are rehoused.
yeah,
Another thing is, you tend to see sort of on financial statements that the parties have to produce when, to help them decide, how the matrimonial assets would be split,
yeah,
is that you see these overinflating of budgets. So like, £1,000 a month on food shopping, or, £1,000 a month on hair and beauty and stuff.
yeah,
And invariably judges will say, well, now you've got to cut your cloth accordingly.
yeah,
So, if you used to have beauty treatments and your hair blow dried every Friday, well, maybe it's going to have to be once a month.
yeah,
So it's all again about, you have this one pot,
yeah,
the judge now has to provide for two households. How do I split that? And if
yeah,
that means that you now are not going out every weekend, and it's probably once a month, or you can't buy, rehouse in a four-bedroom semi-detached house or detached house, you have to get a flat or a
yeah,
one-bedroom property or something like that. So be it, because
yeah,
it's just about ensuring that you are able to live, not necessarily in the same standard that you were. But then that's saying that for the ordinary client.
yeah,
I
yeah,
think that, where we're talking about these divorces where there's millions of pounds, I think there's a
yeah,
slightly different argument. But then saying that, there have been cases where, you know, uh, um, there was a case recently, and it's called MM and NM, and this
okay.
was a dispute regarding the terms of a prenuptial agreement.
Oh, yes.
So within the prenuptial agreement, the wife was to receive this housing fund, which I think was about 11 million, something
Okay.
like that.
Nice.
She, which is, yeah, I wish most most clients were arguing about whether I get a million, 11 million, or 12 million. But she
Yeah.
wanted 18 million.
Okay.
And so after many court hearings and hundreds of thousands of pounds of court fees, the judge deemed that within the 11 million pounds she was due to receive under prenuptial agreement, her needs could be met.
Yeah.
So essentially, if your needs can be met within a smaller budget,
Hmm.
maybe a slightly toned down lifestyle,
Yeah.
again, the judge would have said that they have discharged their duty.
Yeah. Understood. So,
Mhm.
this leads to the question, and I know this is easily can easily turn into a rabbit hole because there's a lot to be said about it, but it does lead to the question of how do you define the matrimonial pot to start with, right? What is it that you're splitting in two? And so you end up seeing people actually fighting tooth and nail, not that much about the percentage split, but more about what there is to split to start with. Could you give us, at a high level, how we define matrimonial versus non-matrimonial assets?
Okay, so non-matrimonial tends to be assets that you bring into the relationship,
Yeah.
but they haven't been commingled
Hmm.
during the marriage. So sometimes you will get couples who maybe have an investment property, say.
Yeah.
Um, and so if that's always been a property that has been separate,
Hmm.
they've never lived in that property together, the income that if it's rented out, the income has never been used on matrimonial expenses,
Yeah.
living expenses, the joint living expenses, then that will be considered non-matrimonial.
Yeah.
Similarly, inheritances are non-matrimonial,
Hmm.
and particularly if they haven't been commingled.
Yeah.
Anything that was generally acquired during the marriage,
Hmm.
so obviously the matrimony, the family home, you know, any lump sum savings, those sorts of things.
Yeah.
If you received say an inheritance and you used it for the during the relationship, so if you used it maybe to buy a bigger property or you know, spent it on expenses and stuff, then it becomes matrimonial. And
Yeah.
you're right, Chloe, a lot of couples argue about, well, I brought that into the marriage. Okay, well, when did you bring it into the marriage? All right, 20 years ago. Okay, well, that the court's not going to look back and say, okay, well, that's not matrimonial. And what did you do with that? Oh, well, we lived in that house, or I used that money to pay for this and pay for that. So it
Yeah.
becomes matrimonialized. Yeah,
Yes. And it's
yeah.
often hard for people to accept because in their